Hey viewers, you're watching the Savera and I'm Vidhi Joshi. The Supreme Court on Tuesday, that is today, ruled that only individuals belonging to Hindu, Sikh and Buddhist religions can hold scheduled caste status, clarifying that those who convert to Christianity or any other religion automatically lose the benefits and protections associated with it. A bench of Justices Prashant Kumar Mishra and Manmohan Anjaria stated that a Dalit who converts to Christianity cannot claim protection under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. The court emphasized that the constitutional and statutory protections are meant exclusively for members of the recognized scheduled caste communities within Hinduism, Sikhism and Buddhism, and do not extend to all those who voluntarily adopt another faith. Well, the verdict arose from a petition filed by Chitanda Anand, a pastor from Andhra Pradesh, challenging the Andhra Pradesh High Court's May 2025 decision. Anand, originally from the Mala community, a scheduled caste, had converted to Christianity and taken on priesthood. He alleged that he faced caste-based discrimination and abuse from certain individuals including Akkala Rami Reddy and filed a complaint under the SC/ST Act. The High Court had refused to hear the case, noting that the SC/ST Act protects only individuals who belong to the specified scheduled castes or scheduled tribes and cannot be invoked by someone who has voluntarily left that category by converting to another religion. And during the investigation, it was revealed that Anand's scheduled caste certificate had been revoked after his conversion, and he had been actively functioning as a pastor for about 10 years. The High Court observed that merely possessing a caste certificate cannot justify protection once an individual has embraced another religion. It noted that the caste system, which underlines SC status and the SC/ST Act, is aligned to Christianity, and therefore a convert cannot claim protections designed for caste-based discrimination within the Hindu social structure. The Supreme Court upheld the High Court's reasoning, citing the Constitution Scheduled Caste Order 1950, which restricts scheduled caste status to Hindu, Sikh and Buddhist communities. Conversion beyond all these faiths automatically disqualifies an individual from claiming such status. The court clarified that the determining factor is the religion practiced at the time of the incident, not merely the possession of a caste certificate. Anand had not claimed reconversion to his original faith nor presented evidence of re-acceptance into his caste community. Instead, records showed that he had been actively practicing Christianity, conducting prayer meetings and performing pastoral duties for over a decade, establishing his ineligibility for SC status and protections under the SC/ST Act. The case dates back to a 2021 complaint filed by Anand, alleging that certain individuals opposed his evangelical activities, assaulted him and used caste-based slurs. Police registered offences under the SC/ST Act and the Indian Penal Code, and one of the accused, Akkala Rami Reddy, moved the High Court to quash the proceedings, arguing that invoking the SC/ST Act was legally untenable given Anand's conversion. The High Court agreed, noting that allowing such claims would amount to a misuse of the statute. Well, the Supreme Court's verdict reinforces earlier rulings, including the 1985 Union of Indian case, which held that conversion solely to the avail of scheduled caste benefits violates the Constitution. The decision makes it clear that legal entitlements associated with SC identity, including protection under the SC/ST Act, cease once an individual voluntarily converts to a religion outside the recognized faiths.
That today the Supreme Court passed a very important order, an order that will have repercussions all over the country. We have not got the full copy of the order, but what we can tell you is what we have submitted to the court. Our essential submission was that a person who has converted himself from SC/ST caste into Christianity cannot take the benefits of the Act. He cannot get the benefits or use its protection also. This is a culmination of a long line of judgments. But today what the court has laid down is very important. It will have a lot of implications for people. And the court was very clear and categorical in saying that once you have converted from SC/ST into Christianity, you do not have the benefit of caste because Christianity does not recognize caste. And this is based upon a 1950 presidential order also. That order has been there on the statute book and the court was very clear in reaffirming what was stated earlier in the statute book and in the judgments.
Sir, what? So do you think that if that matter is settled, then it will have also impact?
No, I think what we have argued is slightly different, but as I said earlier, till the full judgment copy comes, it would not be correct to venture into another matter, particularly when it is sub judice.
The current judgment, does it resolve the issue completely?
It does. In very categorical terms, it says who is entitled to claim the benefits of the Act, who is not entitled to claim the benefits or the protection of the Act.
The situation can only be changed if somebody comes in the court in form of a review or challenging the judgment.
That is an option that is open to them. We cannot prevent them from saying it. As far as things have, for today, I am talking of what we all as a team submitted.
The tendency of the larger issue won't affect today's judgment.
Should not affect today's. It was a case of where a person who was professing Christianity has filed a case under the SC/ST Act against somebody in the village. So our argument essentially, both of us, what we had submitted, once he converts himself to Christianity, and admittedly he was a pastor. So
That's all for now. Stay tuned to the Savera for more updates. Do like, comment and subscribe to the channel.